I'm Larry Slade, the street savvy lawyer, here to talk to you today about the top 10 ways to stay out of court. Now, it might sound a little strange for a litigator to advise potential clients on ways to stay out of court, but that is exactly what I'm here to do today. Rule number 1 for staying out of court: do your due. And when I say do, I mean due diligence. Do your due diligence. The first rule of staying out of court is that you have to know who you're doing business with. You have to have an understanding of how long they've been in the industry, what their customers are saying about them, what kind of referrals they've had, what kind of complaints, if any, have been made against them. Google them. Go online. We have a lot of technology available now to help us. 20 years ago, you can only go on someone's recommendation, but now you can go on the recommendation of hundreds of people. You need to know who you're about to do a deal with. If you don't take the time to do your due diligence, then you're taking a flyer. You're going on trust, and you may get burned. Rule number 2 for staying out of court is to evaluate the deal. You've got to think very carefully about what the terms are of any given deal that you have. Most specifically, you need to understand not just what you're getting from it, but what the other side is getting for it. You need to be able to answer the question, what's in it for them? If you don't know why the other side might do a deal, and you're on the verge of doing a win-lose deal with someone else, you're really on the verge of doing a lose-lose deal. Let's say that you want to hire a contractor to remodel your house, and you get 4 quotes. The top 3 are within range of each other, and one of them is significantly lower than the other 3. Your natural temptation is to want to go with that low bidder, but that low bidder is telling you something in the context of the other quotes. He or she is telling you that they want the business so badly that they just want to get their foot in the door. Now, it's a natural human instinct to think, I want the best deal that I can get. And I'm not trying to tell you to ignore your instincts, but I'm telling you to chill them a little bit because you don't want to take that lowest bid. That lowest bidder has told you something that you need to listen to. If you take that lowest bid, you're likely to end up into a conflict because that bidder is likely not able to deliver what the other contractors said that they could. Negotiate win-win deals. Make sure that everyone gets something out of it and that you fully understand what the other side is going to get out of it so that you know that you've got a balanced deal and one that the other side is incented to upkeep. Number 3, be clear. When you're negotiating a contract in advance of signing it, you need to make sure that the terms and conditions are clear to both parties. Not only do they need to be in writing, but before you can put them in writing, everyone has to understand what they are. Think of it this way. Imagine a contract when it's being negotiated is like a dirty window through which you cannot see. It's your obligation and the other party's obligation to polish that window, making it clearer and clearer as to what is on the other side. What are my rights? What are my obligations? What are my performance duties? When do I have to perform? How do I have to perform? What materials will be used? How much money will be paid and in what terms? Subject to what conditions? These things need to be clear, and if they're not clear, it is in that ambiguity, through that now dirty window still, that parties will reach a conflict because they're not on the same page about what they were supposed to do in the first place. The 2 most important parts of the contract are the terms that are spelled out up front and any exhibits that might be attached to the contract. I can't tell you how many times I've seen a contract where all the meat of the contract is referred to in Exhibit A, but there's no Exhibit A attached. Make sure that the exhibits are attached and that they're clear. The effort to make it clear will help you stay out of court because there won't be confusion as to who's supposed to do what. Rule number 4 for the best ways to stay out of court is write it down. Now, this might sound obvious, but you'd be amazed at how many people don't have written contracts. Equally as important, people think that a written contract is always formal, where it's a multi-page piece of paper that recites the terms at the front and everyone signs at the end. That is the optimal way to do a contract, but that's not the only way. You can have an email exchange with someone else where you spell out the terms. You make an offer for them to perform a service. They accept that offer and specify how much it'll cost, when they'll start, what materials they will use. That back and forth of your emails is a written contract. Now again, it's not ideal, but there's more than one way to do it. That sometimes is the simplest and fastest way to get a deal done, especially when the value of the deal doesn't justify a formal written contract or a visit to a lawyer. Don't put yourself in a position where you have nothing in writing. You don't want to be in a position where you do what my great uncle used to call a handshake deal. Well, I tell you, kid, I do a handshake deal and my word is my bond. Now, my uncle was great at honoring the terms of that agreement. He was very old school, but old school won't fly anymore. You don't want to find yourself in a position where the terms of your contract are subject to he said, she said, well, you said you would do this and I said I would do that and we never agreed to that. If you have it in writing, you're able to prove exactly what was agreed to. Rule number 5 to stay out of court, stay on top of it. During the term of your contract, don't fall asleep. Pay attention to what your obligations are, what the timing of your obligations are, and more importantly, what the timing of the other person's obligations are. Don't convey to them the message that you're asleep at the wheel, because that's when people will take advantage of you and breach the contract, because they know you're not paying attention. When you're diligent and you stay on top of the terms of the contract and you re-clarify and you re-clear exactly who's supposed to do what when, you convey the message to the other side that you're taking it seriously and you're going to hold them to the terms. Conversely, if you don't do that, you're conveying exactly the wrong message. What you're telling them is, do it when you want, the way you want, and I'm really not here. I'm not paying attention. Well, you've got to be present. You've got to be focused. You've got to communicate, and you must stay on top of it. Rule number 6 for staying out of court is don't ignore problems. Problems inevitably come up. You have to address them proactively. You have to start by acknowledging them and then communicating with the other side and negotiating your way through them. It is all too common in business and in life where people act like the proverbial ostrich. Do not stick your head in the sand. The problems will not go away on their own. If the other side seems unhappy about something, but yet you're happy about it, don't assume that it's just going to go away. You need to address it with them proactively. Talk to them, call them, sit down with them, ask them what they think. Because if they're dissatisfied, they're going to look for a way either out of the contract or through the contract in a manner that you don't appreciate. Don't stick your head in the sand. Don't ignore it. Don't assume someone else will handle it. There is no someone else. It's just you. Deal with it. Rule number 7. It's not personal. This is one of the most important rules for staying out of court because people often forget this. When you're in a business relationship or you're negotiating a deal, it's a negotiation. Don't take it personally when the other side asks you to do something that you're not comfortable doing, to make a compromise that you're not comfortable compromising on, to cut a price that you're not comfortable cutting. Just say no. Don't get upset. Don't get frustrated. Don't be hurt or offended because it's not personal. It's business. Treat it like business and learn how to say no. If the other side can accept it, great. If they can't, then you don't have agreement. I see this all the time. I see clients saying to me, I can't believe what they said to me. How outrageous. They clearly have no respect for me. That's not true. It's not that they don't have any respect for you, and their respect for you is not really relevant. What's relevant is whether or not you can get the deal under terms that you're comfortable with. Rule number 8 for staying out of court is count the money. When a dispute arises, the first thing that you want to know is how much money is at stake. What is the amount in controversy? If it's $10,000 or $15,000, you need to find a way to stay out of court. If it's $100,000 or more, then going to court might make sense, but you can't make that decision until you understand from a non-emotional standpoint what is in controversy, how much is at stake. The answer to that question will give you a business perspective on whether or not it makes sense to litigate. If the money doesn't justify it, because litigation is very expensive. I do this for a living and I can tell you it's unpredictable and expensive. And if you have a $15,000 or a $20,000 dispute, you don't want to find yourself in litigation. You want to avoid it at all costs. Rule number 9 for staying out of court, consider the lost opportunity. So if you find yourself in a position where you're in a conflict with someone and you're on the verge of filing a lawsuit, one of the factors you need to consider is how much is it going to cost you to litigate. Now, I'm not talking about the dollars and cents of it. I've already talked about that in the prior rule. What I'm talking about now is what is it going to cost you in terms of what else you could be doing rather than litigating. We refer to that as lost opportunity. You have a fixed number of hours in a day, and if you spend them litigating, what could you have been doing otherwise that could have helped you recoup the funds that you're trying to recoup through the litigation? In considering the lost opportunity cost of litigation, it's important that you also understand the mental and emotional component. When you're embroiled in litigation, sometimes it's all you can see, it's all you can feel, and it can be all-consuming. What opportunities will you be losing if you're doing this litigation instead of focusing on your business? Rule number 10 for staying out of court is that there is no joy in being right. This is perhaps the most important rule of all. And what I mean by this is people often find themselves litigating to prove a point, a matter of principle. I was right, they were wrong, and I'm going to prove it. The court system is a poor vehicle to prove that you're right. If you are so committed to being vindicated, you will find yourself deeply embroiled in litigation, not once, but many times. So the moral to the story is this: there is no joy in being right. The courts are ill-equipped to vindicate you. You should embrace the possibility that maybe you're not as right as you thought. There are two sides to every story. Not one story is black and white. Everybody is right and wrong to varying degrees. This is not how these things are resolved. And if you're committed to being right, if you feel that you're right and you need to prove it to the other side, you're going to perpetuate the litigation you're involved with and give rise to new litigation. If you can approach business disputes from the mentality that says, maybe there's something about this and I don't understand. Maybe the other side has a point. Maybe from their perspective, I'm wrong. If you can take the time and energy to think about what the other side may think, and more importantly, to accept the notion that you are perhaps not as right as you think you are, you can put yourself in a proper mental state to resolve and avoid disputes at all. But if it's all about proving that you're right, if you have to be vindicated, they got a spot waiting for you in court. There's a jury waiting to hear your case. Have you ever been in a situation where after a business deal you find yourself thinking, I wish I knew then what I know now? Tell me about it in the comments.